welcome everyone. My name is Joseph Kohm, if I have not had the privilege of meeting you. I'm the Policy Director here at Family Policy Alliance. Welcome to Skrmetti Scrutinized, and this session is going to be a combination of a celebration and a vision casting for a way forward and the need for it. So I'm so honored to get to host this with two of my great colleagues and friends. I said this was a celebration, that's because it is. We're celebrating after 8 years of having written a policy when it was unpopular to protect kids from something that the world at the time thought was very popular. 8 years later, the constitutional scrutiny we knew it would face has vindicated us and some of our allies, which you'll meet in a few minutes. That is FPA's Model Help Not Harm Bill, which was written all the way back in 2017 to protect kids from what was termed gender-affirming care, or at least the physiological aspects of it. So that's puberty blockers, cross-sex hormones, and then the actual transition surgeries. And we knew at the time we wrote it, this will one day, if successful, if our vision plays out, that the Supreme Court will have to evaluate this constitutionally. And we wrote it back then with that in mind and have revised it with that in mind since. So with 25 states having passed that law, there was a lot riding on United States versus Skrmetti, and we got our movement got a full-throated vindication from the court in just a brilliantly written opinion. So this plenary session is celebrating that and showing where we go. This is how I talked about it, how I've been talking about it since then for FPA, is that the Skrmetti ruling created a civil rights springboard from which we can press our advance against gender ideology and public policy with multiple watershed public policies. This session is going to present to you what we consider at FPA the two cornerstone model public policies that we think social conservatives should pursue in light of the Skrmetti decision. They are the Model Defining Child Abuse Protection Act from the Heritage Foundation and the Model Detransitioners Bill of Rights from Do No Harm Medicine. FPA's position is that every state and the federal government needs both of those bills and a Help Not Harm bill if they do not have it, or a version of our Help Not Harm bill or Do No Harm's original Do No Harm model bill. Every state in the union needs these bills. And so this is designed to kick off that movement that FPA wants to put all our focus behind to get every state to run those bills because Skrmetti says you can, and we think you should. So that's what we're going to talk about. I have some great panelists up here who you'll meet in a second. I do want to give some gratitude, though, for the people that got us here. So first of all, it's all the FPC leaders, because without them, we don't get here. You don't get to 25 states that passed this law. You don't get to such a ringing Supreme Court endorsement. So the FPC leaders who helped get us here. Also, all the state representatives and some Statesman Academy alumni who courageously sponsored these bills. And I'd be remiss if I didn't mention Robin Lundstrom as the first one who did this. Yes, she deserves your applause. I thought of her that day Skrmetti came out, because what a vindication that must have been for her and all she faced for it. And I want to especially thank, along with her, the people that shepherded her through, which was Arkansas Family Council, the courageous FPC, one of the rocks of our movement, that helped carry them through that. And as well, part of the Skrmetti case was the case over the law in Tennessee, of course, but it was actually a joined case for the lawsuit over that law and over the Help Not Harm law in Kentucky, which was, again, shepherded by a great state FPC, Kentucky Family Foundation, and sponsored by one of our great Statesman Academy alumni, Representative Jennifer Decker. We're so thankful to all of them and to all of you who threw any kind of support behind this movement. This is a celebration of what God has achieved through you. So thank you. So with that said, I have some great panelists to talk about where we go from here, the policy landscape as we see it going forward from Skrmetti as a civil rights springboard. These are my three panelists who I'm so honored to have up here and can't wait to hear from. We have Laura Hanford, who's a visiting fellow from the Heritage Foundation. Next to her is Josh Hershberger from the Indiana Family Institute, our host FPC for this conference. And then all the way at the end is Dr. Miceli from Do No Harm Medicine. I'm so thankful for all three of them and the people they represent. That was half the fun of constructing this session, is Laura's from Heritage, just one of our just eternal partners, it feels like, but one of our most important, critical ones. You heard a little from them last night. We love Heritage at FPA. Indiana Family Institute, leader in the FPC movement, and our host here is represented on this panel. And Do No Harm Medicine, a more recent partner for us, but an absolutely critical one to getting us to where we are today at this movement, and to go forward into where we see a world that has righted its ship in regards to gender ideology. So I want to kick this off. I'm going to sit down and join them here. Now that we have Skrmetti, when I was drafting this outline, I realized there were parts I just couldn't write. So we had the opinion, which only came out a few weeks ago. So now that we have it, I could write the first question to everyone, which is, this is how I've summarized Skrmetti a little bit longer. The Skrmetti ruling is a landmark for this movement and has laid a sturdy constitutional framework for this civil rights revolution that is the Help Not Harm campaign. The court made clear that transgenderism is not an immutable characteristic and is therefore not elevated to a higher level of constitutional scrutiny by the court, which makes it easier in turn for all of you to pass good state laws on this issue. Furthermore, both Chief Justice Roberts and Justice Thomas took note of how splintered the medical community and medical professionals are in this area. They specifically cited the Cass Review out of the UK. And this recognition of concerns with so-called gender-affirming care is a positive sign of cultural change. This is one of those moments where it's not policy is downstream from culture or vice versa. It's all one and the same. This has been a pretty collective, measured wave across all the institutions of our society. So I want to start by just hearing from each of you, top line, about what the decision in Skrmetti means for this movement to protect vulnerable people, children and families, from gender ideology. And we'll go in order. I'm going to start with Kurt on the end. Dr. Miceli, just tell us in your mind, what's the overarching message for what Skrmetti means for this movement?
Sure, this is a powerful decision, and again, thank you for having me here as well from Do No Harm. Skrmetti is really so much oxygen in the room in terms of allowing our children to be safe, to be secure from really what has been these past years. And I look back to really the concurrence that Justice Thomas wrote, and to look at the remarks that he made about the expert class, and just how not expert they've really been. And I think to William F. Buckley, and I think to his quote that he'd rather be ruled by the first 100 people in the phone book, and I would certainly agree. I'd rather take their rule than I would the rule of the American Medical Association or the Endocrine Society or the American Academy of Pediatrics. And it's just so unfortunate where medical societies have been, that we've allowed this sort of notion of experts, so-called experts, to lead the fray, and really to do that without any semblance in the evidence. And I think that's one of the key things that the Skrmetti ruling has shown us, is that when you do look at the evidence, when you look at things like the Cass Review, or you look at systematic reviews, when you look at other countries that have actually studied the data, you find that the evidence just isn't there for these procedures, these sex trait modifications on youth. And the harms are so great, and I think that is the part that we can't forget. And certainly in medicine, for any physician, for any provider, our calling is to do no harm, right? To treat patients for who they are as individuals, to care for them with compassion and love, but to do no harm. And unfortunately, there's been tremendous harm that has been done by these the so-called gender-affirming care or pediatric medical transition. And it's great to have a ruling that gives power back to the states, that allows the people to decide and really have their will known, that pediatric medical transition is not what we want for our children, and that we want to keep our kids safe. So I'm thrilled by it, and I hope that organized medicine, medical societies will wake up as well and recognize that it is time to look at the evidence and to be leaders by looking at the data, looking at the science, and recognizing that pediatric medical transition is just wrong and dangerous, and it needs to end.
Excellent. You're all going to hear a lot more about that from Kurt later. So, Josh, your turn. What does it mean for you?
Yeah, so as a host FPC, I may take just a brief point of privilege. We have Senator Tyler Johnson in the room, who came in as a freshman senator, and one of the first bills he handled was Help Not Harm. I don't know, Tyler, if you want to raise your hand there and help shepherd it through. We'll get to some of our state reps here, but just grateful for his work. A couple of thoughts on Skrmetti. First, as an attorney, having some limit to the extent of Bostock is so helpful. It applied in the Title VII context under employment, but that's been used by advocates against us. Well, surely it applies to schools. Surely it applies in equal protection. And then having Gorsuch not say anything during the oral arguments. Now having the Title IX challenge accepted by the Supreme Court. That certainly gives me hope that Bostock decision is limited and we can advocate accordingly. The other issue, specifically in the parental rights arena, which I'll speak to today, is the constant refrain that if you do not affirm a child's gender ideology, whether it's through social or physical transition, they will commit suicide. That has been used in our cases. We have seen that in case law, something I'm sure that all of you have dealt with. and have the admission during the oral argument that it doesn't in fact lead to committed suicide or completed suicide, and then to get the great opinion that we have, that can undermine that argument that's been thrown at us again and again. And then one specifically for parental rights that I'm looking forward to using is surely a constitutional act of a state. So a constitutional law or act of a state is not an act of abuse by a parent. So surely a constitutional act of a state is not an act of abuse by a parent. One of the best ways, I think, to characterize these laws is the state has taken off the medical menu hormones, therapies, gender transition surgeries. If that is a constitutional act of a legislature, a parent saying the same thing about their own child is not an act of abuse. And so this case gives us that ammunition in our tool belt as we go into parental rights cases.
Well, that's so good, Josh. Exactly. I know you're going to talk more about that, having already made some incredible progress on it here. So Laura, you're next.
Yeah, thanks. It's a real pleasure to be here with you all. The way we value the alliance is just as strong as you were expressing. So Skrmetti is obviously hugely significant. It took on the lie that these interventions are evidence-based, the suicide myth. It regrounded the discussion in biological reality. My particular interest is that it held that not affirming is in fact not discriminating against a particular identity, as you were mentioning. It's not a full decision on that aspect, but it's a major blow to the idea. And the reason that's important is discrimination is the hook for these really awful policies. It's not a benign, be nice to everyone. It's you are denying my identity by withholding medicine, by not calling me by my chosen name, et cetera. And so that's how we get these horrible policies.
Yeah, that's excellent. And now we're going to use that to start diving in, because you're next on my list here, Laura. We're going to talk first about the Model Defining Abuse Child Protection Act, which was authored by Laura, had a little bit of a hand in it, but it was really her project. And it's an excellent piece of model legislation, because what we've seen is we've had all this success on these, help no harm, do no harm laws, specifically on the actual surgeries and procedures. And now what we're seeing as the other side really shifts and moves, changes their vector of attack, is that it's really bringing across into this area another key issue area for most of us in our organizations in this room, which is parental rights. That's why I have Josh up here to tell you what that looks like in practice and to protect it in this brave new world that we're in. But Laura's going to summarize really the issue with it and why this law was drafted. So Laura, I want you to just tell us about this next step in countering that problem, protecting traditionally minded parents, because it's clear from the other side that's their new vector of attack. Let me see if I can get your slides going here. There you go.
Thank you. All right, so this is really the premise that we're up against. This is official government policy against under Biden, but you need to be aware that this has been taught and ingrained most of all in child welfare systems for 20 years. So everyone dealing with children coming into the child welfare system, school counselors that are taught to be mandatory reporters, doctors, judges, all of them have this view. And so Skrmetti is a huge blow. That's the medical piece, but that's not the only piece. And so the assault is multifaceted. Activists see kids as critical to reshaping society in the form that they want, and parents, of course, are the greatest obstacle, which is where secrecy comes in, because you have to reach the kids to alienate them enough that you can get to them, and then you can bring in others to say that, like CPS and doctors and judges, to say the child is no longer safe because their identity is not being affirmed. And so this is a recent court symposium, and I want you to just notice the three areas: schools, gender affirming care, so that's the medicine, and family regulation, so that's CPS, families, family law. They know, and this is, of course, this is their view. It's not a question of whether parental rights are in the interest of children. Actually, really it is. But whether parental rights are in the interest of all of us. So that's what we're up against. For parents who are pulled in, so doctors, here's a doctor opinion, a new paper from the American Academy of Pediatrics, who are also one of the big promoters of the damage that we've seen Skrmetti take on, that it's a form of abuse. So if it's in the best interest of the child to affirm their identities, withholding that is, of course, abuse. And so Schools are really the vector. So deception, this model policy is 10 years old. This hit my school 10 years ago. And what I want you to notice is that they believe school personnel have unique insight into the students' needs without the biases that parents can have. And they train the school counselors to be ready to highlight to the judge the importance of affirming, because the school personnel have a fuller understanding of the child's needs. So these are all, so when you are a parent who's pulled into this, it's like you're in the twilight zone. All the people that are supposed to protect your child and these structures that are designed to educate, protect your child against harm actually become this phalanx of, it's like Hotel California. You can check in, you can never check out. They're all lined up against you, and you who have cared for a child your entire life, based on 5 minutes of observation by a judge, a CPS worker, someone else, are suddenly the villain and the abuser. So in the child welfare system, this is the healthy approach. Again, this is official Children's Bureau policy from the last administration. Consider school and community interventions. There's CPS, there's the hook with CPS again. And then you get this aberration of a view here. This is one, the National Child Traumatic Stress Network trains child advocacy centers all over the country to recognize abuse, and this is the screener they recommend using. And so just to give you a very quick taste, you've got about 12 or 13 options. They're asking kids, sometimes as young as 2 or 3 or 4 or 5, what their gender identity is. And then you also get this, that's also where you get, this was the survey that was handed to my 13-year-old last year in the ER when I stepped out. They're checking to see if I'm abusive because they want to know his pronouns and all of his sexual activity, but not while I'm in the room. So this is really why we need to, this is comprehensive, and I can't emphasize this enough, that these tracks work together. And people that haven't had this experience with CPS have no idea how deep it goes. And I want to remember, you need to be armed to protect yourself, and one of the best resources as churches, legislators, is Child and Parental Rights Campaign's resource for churches. Noelle, I'm gonna give you a shout out. She's right here with, she's also a state legislator, which is wonderful. She's holding it up, but churches need this. It says what to do. It's got some good training, what to do if CPS shows up on your doorstep. So the Defining Abuse Child Protection Act basically goes up against all of these things. And we're drawing off, I don't know that we have time to go into Sage's story, but Sage, this is based on our experience actually with our amazing family foundation in Virginia, a bill called Sage's Law that we worked on to address the 2 failures that contributed to what happened to her, which is 1, school secrecy, and secondly, that you cannot define abuse to mean withholding affirming care, meaning that you cannot take a child, you can't rip a child away from a family or deny a foster child placement with a family based on this faulty definition of abuse. So let me see. Sage, just, I would refer you to her story, a couple articles that I've written in the Federalist that came out at the same time when when we introduced Sage's Law, which again, this is based on, but she was transitioned secretly at school and ran away after being assaulted in the bathroom. This counselor told her to use. When she was found by the FBI after the worst nightmare possible, I mean, I have kids this age, she was trafficked, raped for 8 days. The FBI found her in Maryland, and the judge would not give her back because the public defender was accusing her parents of abusing her on the grounds of abuse. And that set off a whole nother nightmare. The judge denied the mother's request to place her in a treatment center in Virginia that would have treated her as a female victim of trafficking. And Sage ended up running away and being caught for 2 more months by predators. It's a mind-boggling amount of cruelty that went into her situation. So, real quickly, the foundation of the Defining Abuse Child Protection Act is that it defines abuse specifically to exclude not affirming a child. So it says a parent's rights include the right to raise and refer to a child according to their biology. And we have, you can look it up. We also have a fact sheet that lines up all these stories. States must refuse to define abuse as raising a child according to his or her biology. And so we go after training, their foster and foster parent protections, parental protections. We cut off the training. We cut off funding for the training. We cut off any kind of secrecy based on this concept. So basically rooting out everywhere this faulty concept has taken hold and damaged parents.
It's excellent. I cannot recommend this model policy enough. There's a lot of Statesman Academy, alumni, current classes in here, FPCs. This is the policy we're recommending to you on this issue area for going forward from Skrmetti. This is what's coming, I think, which is why I want to ask you what's also coming, Laura. This policy is birthed out of a particular worldview that I think everyone in here shares, that parents have the right given by God to direct the upbringing of their children and the responsibility to do that. There is a competing worldview and a competing policy that is completely incompatible with this, and it's basically the inverse. Laura has experience with that too, and we saw this year, Family Policy Alliance, many others, opposed this law in Colorado that would have done pretty much the exact opposite. Just Laura, just tell us, what would that competing policy have done, or what will it do?
So Colorado's bill, HB 13, I want to just show you here what Colorado brags about. It's literally a thing, the transcontinental pipeline. So they brag about recruiting kids from other states that are not affirming. And that was part of the bill, was they were protecting people in Colorado from having to return children who ran or were taken by an adult, not necessarily related to them, to Colorado for gender-affirming care. Colorado, Washington, Oregon, California, of course, all have policies like this. Until we deal with this issue at a state level, even if you ban it in your state, at a federal level, even if you ban it in your state, your kid can just go get it somewhere else and not be returned to you. But so Colorado, that was in there, and they specifically defined not affirming as a form of abuse. And so interestingly enough, this is where everyone mobilized. They had the record number of people testifying against it. And the saddest part was that there was a Christian father who had had his daughter taken away to be transed by his ex-wife. The ex-wife came and testified for the bill with the child sitting next to her and trashed the husband. That is not normal, and not in any stretch of the imagination can that be considered in the best interest of the child.
And a lot of us know, a lot of CPSs in your states, this is what they've been doing kind of secretly, implicitly for years. What was so audacious about at least the original draft of the Colorado bill is it basically just was out with it. They dropped all pretenses, and they were open about it. They said, if this is the way you're going to treat your kids, the new law is going to label you abusive. And the law that finally did pass, it does that in a more underhanded way. It adds it to the anti-discrimination code in Colorado.
There's the hook. It's the discrimination, the anti-discrimination hook.
Which is presumptively unfit parent.
Right.
So that did pass. Governor Polis signed that into law, sadly, in Colorado. Fortunately, a version of the Defining Abuse Act did also pass in the state this year. That's what Josh is here to tell us about. And how that came about, because what I said about CPS doing this implicitly for years, is kind of what drove that. So Josh, just first of all, tell us about the version of the Defining Abuse bill that passed. It's House Bill 1412 or House Bill 1412. The first state to take this step. You guys led the way, followed by North Carolina, by the way. So there are two states that have done this. John Rustin and Mitch Prosser, shout out to them at North Carolina Family Policy Council. IFI led the way. Josh, how did it happen?
So it's impossible to tell the story of HB 1412 without Mary and Jeremy Cox. Our clients, Mary and Jeremy Cox, are devout Christians who believe that God created us male and female, and that raising our children according to their biological sex is best for them. Jeremy is a software engineer. Mary has an advanced degree and works in the medical field. Prior to what I'm about to describe to you, they had never interacted with the Department of Child Services. In 2021, the Department of Child Services began to investigate their home because they would not use transgender or cross-gender pronouns. And DCS filed a motion to remove their son from their home because they would not accept an LGBTQ resource that was contrary to their religious beliefs. This, of course, was astounding. Surely this is not the case. At the initial hearing, I'd like to read to you exactly what DCS argued. We just feel that at this point in time, this child needs to be in a home that's not going to teach her, biological male, teach her that trans, like everything about transgender, tell her how she should think and how she should feel. However, she should be in a home where she is accepted for who she is. Despite the fact that the Cox family was caring for all of their son's physical, medical, educational needs, and despite the fact that they provided evidence that they were following their doctor's recommendation concerning an eating habit, the state removed their son from their home, placed him in a home specifically chosen because that foster placement would affirm their son's transgender identity, and barred them from speaking about the entire topic of gender with their own son. Now, those in this room know this, but the Supreme Court has declared the right of parents to raise their kids as the oldest and most fundamental liberty interest. And DCS in this testimony declared that what Christians have believed for more than 20 centuries in good faith was abuse or neglect. After 5 months of litigation, DCS agreed to voluntarily dismiss all of the allegations against the parents and unsubstantiated the charges of neglect and abuse, pulling them off of the Child Protection Index. Legally, as we all know and we rely on in the protection of our own kids, a state cannot remove my child unless they can prove I am an unfit parent, meaning that I have abused them or I have neglected them. And in fact, the Supreme Court said this in Quillian versus Walcott. States can't force the breakup of a natural family without some showing of unfitness, and for the sole reason that to do so was thought to be in the children's best interest. So at the next hearing, after the state voluntarily dismissed the allegations against the parents agreed that their son was engaged in self-endangering behavior, refusing to return to their safe and protective home. At the next hearing, DCS argued, to our surprise, that the child should remain out of the home after declaring the parents fit, saying that transgenderism was a barrier to return to home, and claiming that the eating disorder had gotten worse, failing to recognize that it had gotten worse in the state's custody and not the parents. We filed motion after motion, despite bringing in evidence from national experts that have now been formalized in Skrmetti. The state continued that removal for more than 2 years and never replaced their son in their home prior to aging out. We appealed to the Indiana Supreme Court. The Indiana Supreme Court, or the Indiana Court of Appeals first, found that the state's actions passed strict scrutiny and held that the private speech of parents with their own children in their own home did not merit First Amendment protection. We appealed to the Indiana Supreme Court, that did not take the case. We then appealed to the United States Supreme Court, citing much of what Laura has talked about in states like Colorado or Minnesota, Washington, and California, saying that the Supreme Court hasn't had a landmark parental rights decision in almost a quarter century, and something needs to be done. The Supreme Court ordered a response, but ultimately did not take the case. I don't want to belabor this, but I want to mention the human costs I think all of us can feel. No parent should have to choose between their conscience and their child. When the parents appealed this case to the United States Supreme Court, their son terminated their relationship and cut them off. This has real profound human costs. There's an empty chair at Thanksgiving and at Christmas because of what happened here. Now, this decision from the Indiana Court of Appeals left 2 gaping holes in Indiana law. The first one is the comparison of non-affirmation inspired by religious beliefs, equating that to neglect and abuse. That, of course, needed to be fixed. But another sinister development, I would say, is that it changed the removal standard from fitness to best interest of the child, and allows a child to simply claim self-endangerment. Oh, if you don't affirm me, I'll harm myself, and that's sufficient to remove a child from a fit parent. And so we moved in HB 1412 to address both of those. By the way, if in your state you're concerned about this, I'd encourage everyone here to look it up. There are similar self-endangerment laws in almost every state. The site where you can see those collected statutes is Mills Public Schools versus MP, 89 Northeast 3rd, 1170. It's a Massachusetts Supreme Court case. So you can see how that might impact you. So we turned around, and Ryan McCann, our executive director, is here, and our entire team. We've been at this for several years, trying to get this passed. You think, how hard can it be? Raising your kid consistent with their biological sex. Really, it's not that hard. That's not neglect or abuse, but things just take time. And we've kind of joked, we're not a think tank. Maybe we don't have all of the resources of national orgs, but we just don't know when to quit. All right? Maybe it would have been smarter to give up, but we just had to push through. And so we were able to get a parental rights bill through this year, elevates parental rights to a fundamental right. Representative Shane Lindauer here is in the front. who helped shepherd that through. Also, we have Representative Wesco, and I can see McGuire, Davis, and King, who are also supportive of parental rights. If you would give them a hand.
Clap there for them, yes.
And then the other piece, fairly simply, HB 1412 says in 2 places in Indiana Code that raising or referring to your child consistent with their biological sex is not neglect or abuse. The first one is in the reporting statute. So it doesn't matter who calls into the reporting hotline alleging abuse. It is now on the books that simply referring to your child according to their biological sex is not abuse, therefore stopping the entire process from coming against Christian parents and others that hold to these beliefs. The second piece is in what we call our Child in Need of Services statute or the Child Welfare statute. So for DCS, for judges, for trial courts, it very clearly sets out that in no context, whether it's self-endangerment, whether it's neglect or abuse, if you're taking drugs, you're hitting your child physically, that's different. That, of course, is subject to DCS intervention. But in this instance, DCS cannot come against parents. And so we're greatly relieved to finally have that on the books here in Indiana.
Man, it's fantastic. Thank God. I have one more question for each you and Laura before I bring Dr. Miceli in. So Josh, I want to use this metaphor very specifically here. I want to deal with the elephant in the room for a lot of people out here thinking the same thing as me and thinking what I thought when you called me the day the Supreme Court chose not to take their case. And Josh was co-counsel for them. I felt how distraught you guys rightfully were at that. Indiana, we're sitting in a red state. This is a conservative jurisdiction. And for minds of those who don't live here, the first thought is, how could this have happened in the CPS of a red state? So just tell us briefly, how did that happen? Because that's why the need for everybody else here needs to pass this in their state.
So I'll mention in the Cox case, throughout the case that we presented we presented an expert, we presented evidence. The state never presented a single scrap of medical evidence that non-affirmation equals abuse. None. It was simply assumed. Now, you may have heard our comptroller last night talk about the Kinsey Institute. Kinsey Institute at Indiana University has been a pioneer of the sexual revolution, and many of our caseworkers, DCS workers, are trained through the Indiana University School of Social Work, and so it's not too hard to put some of the pieces together. But as we were discussing beforehand, that it was just, and we all have sensed this, right? It is just an assumption that this was the case. And so I think that's true in red states as well as blue states. And again, just one more shout out to our legislators. The Kinsey Institute has in fact been defunded by our legislature in an attempt to remediate that. So I do think that it's just the assumption about transgender ideology and why Skrmetti is so helpful.
Which is baked into all your CPS bureaucracies, all your state court systems. The left has always traditionally been better than us at institutional capture. This is what that leads to. Whatever state you are in, sure, we all know about the Californias of the world. Sorry, Jonathan Keller. We all know that they've been doing this, but for you people who are in Arkansas, Kentucky, Texas, this can happen there. This is why you need this bill. So, Laura, last question for you before we come back at the end. Just how does Skrmetti get us there?
Well, I think Skrmetti is so helpful because it goes at the reason that they're saying it's abuse is because we now have the Supreme Court saying, no, it's not actually settled science that this is best for the child. So you can't take a child away on that basis. So that's part of it, and that it's not an identity that's immutable and that you have to protect from discrimination. I don't know if you know this, but 35 states have foster care laws that say you can't discriminate against gender identity. That includes Iowa, Idaho, North Carolina, Oklahoma. This is a lot deeper than you think. And the child advocacy centers are in 50 states. They're all being trained by people from states like Alabama that you have to use pronouns, that this is affirming the authentic self. This is really deeply ingrained.
Yeah, absolutely. So it's going on deeply ingrained is why I want to talk about our second model policy that I marketed at the outset. I'm going to have Dr. Miceli talk about. Many of you have worked with detransitioners very closely to get us to this point. all these help not harm bills, Skrmetti. You've worked with a detransitioner to get there. Many times I think most of you would say the linchpin to getting us over the line with these good policies was the courageous testimony of detransitioners. They are the other most victimized group that the civil rights revolution is responding to. So, Dr. Miceli, this is why I want to bring you in. In states with or without one of our organization's bills, there's no guardrails around gender-affirming care at all. And particularly, there's no help for those who are devastated by it, for the detransitioners. So I want you to just tell our audience more about what makes detransitioners particularly vulnerable to the victimization that this ideology has caused.
Yeah, I appreciate that question, and certainly hearing from everyone on this panel here. My heart goes out to the detransitioners, to folks who have recognized the terrible harms that the medical establishment has done. And I think it's so important to really conceptualize what folks have been through in terms of taking puberty blockers and the side effects that they may have, in addition to cross-sex hormones and the leading to infertility, sexual dysfunction, bone mineral density loss, cardiovascular complications, higher incidence of blood clots or heart attacks, increased cholesterol. I mean, those are just the drug part, and then to think of the surgeries and the complications that could result from those procedures and such. In addition to the regret and the psychological trauma that folks face, it is a terrible physical, emotional pain, and my heart goes out to hearing detransitioners speak from the heart, and as you said, Joseph, the courage that they have to really speak truth to power is just absolutely incredible, and so it's so important for us to recognize the importance of what we can do to support folks as they detransition. From the medical complications, the needs that they have on that side, there's also the insurance side. There's also, well, how do I pay for these things in my detransition for someone who may need to be on hormones for the rest of their lives because they no longer have the organs that produce those hormones. And so we look at insurance coverage, and the fact is that many insurance companies will pay for transition but will not pay for detransition. And so there's a real serious gap there. And it's important that we have insurance companies pay for that detransition to help these folks who are in the midst of tremendous medical costs and complications as they're experiencing. And then likewise, there's also the legal piece and the challenges that folks face. And folks in terms of transitioning may have changed their names, their pronouns, their birth certificates, their driver's license and such. There's the whole legal nexus that one would need to encounter to change that all back, and the hurdles that they face to get back to being who they are and such. And likewise, the harms that were caused from these physical traumas that have been brought upon them, the emotional scars, the malpractice claims, unfortunately, the regrets often sets in many, many years later, and the malpractice claim may only be able to be brought within 2 years or so, depending on whatever that state law has. And so it's important when we look at detransitioners and folks who may have experienced regret 5, 10, whatever it may be, 15 years later, to recognize that our system of justice isn't really accounting for that fact, isn't really accounting for the fact that, one, when they were making these decisions or when their parents were in the room with them as a child, that consent process wasn't what it should be by any means in regards to anything at all, and how can one have justice in the end. So I think there's just so much for us to consider as we look at a detransitioner Bill of Rights to support detransitioners, to support them, to make sure they have the medical care they need, they have the insurance coverage to provide that medical care, they have the legal recourse in terms of the harms that have been brought upon them. It's such an important issue for us to face and to really protect these vulnerable folks.
The medical industry is so hostile to detransitioners because by their very existence, they irrevocably undermine everything gender ideology puts forward to be true. So how does the Detransitioners Bill of Rights, the model, the way it's written, address those problems? Just briefly summarize for our audience what the bill does.
Yeah, absolutely. So one is that right to the medical care, to actually receive good quality psychotherapy, not in the quote-unquote affirming model, but actually care that warrants and will treat someone and help them to do well through their gender dysphoria, through whatever it might be. One that also provides the medical care that one will need, that provides that right to justice, to seek those malpractice claims and to extend that statute of limitations so that folks who do experience the regret 5, 10 years later will have that that coverage and will be able to seek justice and to obtain justice, to make it easier for one to change their name back to who they were on their driver's license or such, to really allow someone to not face those barriers. And then there's also an element of transparency that is so critical, that it's important for us to know what is actually going on in this gender industry. It's important to know how many transitions are occurring, how many detransitions are occurring. That is critical. I think one of the things that we found at Do No Harm is we put together a database, the Stop the Harm database, that actually looked at claims data from 2019 to 2023 to look at what was going on in this pediatric medical transition world. And the results are astonishing, to actually shed light and to be transparent and to show what was going on, what is being billed in terms of 5,700 surgical procedures that were done to harming kids between 2019 and 2023, tens of thousands of hormones that were being given and prescribed to these children and such. Again, that same transparency is in that detransitioner Bill of Rights, to make sure that there is light brought about it, that the state is aware and that people can be aware as well of what is going on. And then likewise, to make sure that detransitioners have their rights and are protected.
What a wonderful resource that Stop the Harm database is. I mean, I think every FPC here has used it at some point and leveraged it for the good work that we do. So we're so grateful to you for that. A couple notes on just the practical efforts to pass the Detransitioners Bill of Rights. 2 states have passed versions of it. Arizona has gotten it through its legislature. Unfortunately, it was vetoed by Governor Hobbs last year. And then the state of Texas did pass a version of it this year and was signed into law by Governor Abbott. So shout out to Center for Arizona Policy for the work they've done on it, and Texas Values for supporting that. So there is traction, but Do No Harm, we want to partner with you to really push that this year. So I'll have a couple notes on that before we leave. But just widening our scope, Dr. Miceli, one more time for you before we go back to the broader group before questions. Many of us know that we rely so heavily on what good scientific data we can get on this as we advocate for these policies and these positions. I think many of us know in our core that ultimately this battle against gender ideology for the soul of our kids is going to be won by scientists, by medical professionals. Like when they figure out how harmful this is collectively and agree on that, it kind of does our job for us. Like all the policy will fall into line after that. So to that end, help the policymakers in this room just give us a little bit of forecasting of what can they expect coming down the pipeline from the medical community soon on this issue. We've had the CAS review, which was incredible. We've had the Trump 90-day review, which supported that and gave us its own positive conclusions. What else can they look forward to and anticipate being added to their arsenal in the state houses from the scientific community?
Yeah, absolutely. Well, I think one thing to say about the HHS report, the Trump report that was issued in May, is it is really a must-read. It really summarizes what the issues are. I mean, for one, to look at WPATH itself, the World Professional Association of Transgender Health, and to really recognize that here a body, in their standards of care, quote-unquote standards of care, most recently from 2022, was actually making what they called medically necessary statements that aren't medically necessary at all, that aren't based in evidence. It is really important to shine light on that organization and where this is coming from, because I think to the point, when you do look at the evidence, when we do look at the studies that come like the CAS review or reports from Finland or Sweden, we see a very different story. We see the very low evidence of certainty for any benefit, whether on a psychosocial outcome or any outcome of sort. So that review is so critical for folks to really read and to review, and to also understand the very interconnected nexus that medical associations have had, where much of what WPATH was issuing was very much what Endocrine Society had said, and then other medical associations quote what WPATH said. It's this circular argument that the CAS review pointed out so brilliantly as well. And again, really based on no evidence. In fact, when WPATH actually commissioned evidence to be cast by Johns Hopkins, only one of those studies was published out of maybe 10 or so that were commissioned. And so it really begs to question as to where is this data, and the reality is that when we do look at the data, when you look at the HHS umbrella review, which looks at 17 systematic reviews, find 10 that are of high quality, again, the evidence of benefit just isn't there, and the harms are so significant. I think we're seeing a lot of hope, and we continue to see hope from across the seas. There was recently a conference in Europe for child psychiatry, and for the first time, for the first time, there were more folks that were really speaking to the harms of pediatric medical transition as opposed to speaking to the benefits. And, folks remember that much of this came from Europe in terms of the Dutch protocol and the model from the Netherlands. And so here we have a psychiatric conference just held a couple of weeks ago where actually they were outnumbered, and reality and really the science of looking at the evidence was coming forth. It's very encouraging. I mean, we see the Endocrine Society is actually reissuing their guidelines in 2026. We hope they'll come to some semblance of order and conclusion and actually, again, look at the evidence. The American Academy of Pediatrics has promised a systematic review 2 years ago. We're still waiting for it. That hasn't yet occurred. And again, my hope would certainly be that these medical organizations, by seeing what is going on, by understanding where the American people are, by understanding where the evidence is, will come to their senses and really recognize that promoting these policies and guidelines that aren't based in scientific data is just dangerous and harmful to all involved.
That's excellent. So here's how we're going to spend the last few minutes we have of this session. We're going to go into a Q&A time, so I want you to start thinking of your questions. I'm going to ask the first one to these groups and to these folks in a minute while you start thinking of yours. But I want to give just 2 practical notes before we leave. Number 1, out these doors, you're going to find all the exhibit tables if hopefully you've been making your way around to them. To the left is the Heritage Foundation table. There they can give you the website where you can find the Model Defining Abuse Protection Act. You can go out the doors to the left. They will get it for you. Out the door to the right is the Do No Harm table, where they can in turn provide you with the URL for the Detransitioners Bill of Rights. This is for all the Statesman Academy folks in the room, the state legislators, FPCs. Hopefully, after the last 45 minutes, you're eager to run one of these bills, because hopefully the overarching message from this was you can win now. Skrmetti's on your side. You have the mandate to do this. We at FPA and our national partners are here to empower you to do that. Out the door to the left, Heritage. Out the door to the right, Do No Harm. Also at Do No Harm is their External Relations Director, Beth Serio. I don't think she's in here, but she's out at their table. If you want to coordinate with them to work on this bill, which I strongly encourage you to do, she will connect you to the right people on their staff, and also she can connect you to their senior fellows to come in as either witnesses or just consultants as you work on this issue. So I want you to be aware of those 2 resources. They are out there and they're ready to help you as our very generous sponsors. So with that, we're going to do a Q&A time. I'm going to ask the first question to you, which is one I came up with on our outline just as I was having fun with the end of this outline, which is our good friend of this movement who's not here with us this week, but has sold me on this, is Dr. Jay Richards from Heritage. Many of you know, has sold me on, we're going to win this, within a foreseeable amount of time. Our side's going to win this battle ultimately. I really believe that. Jay and others have convinced me. And this is not so what that means is this is not an eternal revolution. Like, we are still the revolution, but this is not a revolution that's going to go on forever. There is going to be an end point where we can recognize we have won. So I'd like just each of you just very, very briefly tell us cast a vision for everybody here, because the Bible says without vision the people perish. What does the world look like when we have finally won this revolution? Maybe we'll start with you, Laura, since it's been a few minutes since we've heard from you. What does the world look like when we've won?
I think it looks like protecting the most vulnerable among us, whether that's kids in foster care or troubled kids who need extra help, or women in prison who are locked in with 6'2" male predators. And I think it looks like in practice having the safeguards in there, parental rights language, there's great parental rights language in Colorado, but they have an exception for abuse. So if you don't close that loophole like Josh did, like North Carolina did, like Texas did, when the crazies are back in, if they are, God forbid, you aren't relying on persuading people that are completely captured. You have a law in your state that protects your kids. So I think that's, we need to put the crazy on the defensive. They do not want to argue on the Senate floor or the House floor that it's abuse to raise a girl as a girl and a boy as a boy. Yeah. They just don't. So make them do it. And North Carolina got 9 Democrats that way. Hats off to North Carolina.
Josh, what do you think?
So I come back to the concept that we flourish when we embrace who God created us to be. Mm-hmm. And I envision a day where so much of this has been debunked, especially our students are just confident in their identity as someone made in the image of God. That our laws then protect the right of parents to pursue that. And then I think a big piece of this, especially in the parental rights space, is that the church comes alongside our departments of child services, our CPS agencies, and works to protect women, children, serve the families in our community, and forces groups like DCS or CPS in those states to provide the religious protections so that church and state can work together as two God-ordained institutions. But I come back to the created order. That's what we've been fighting for all along, and we can't go wrong with that.
That's excellent. Dr. Miceli, finally?
I love your visions. Thank you for sharing them. From the medical standpoint, I really hope that we will have medical societies that will not first issue policy statements and then look for evidence, or maybe not even bother looking for evidence, but will actually look at evidence first and then consider what the policy positions and statements are. I think the medical associations have unfortunately gotten the cart before the horse, and that needs to change. It needs to change in order for us to have trust in medicine, to have trust in our providers, to really respect the integrity of the system. And if we see guidelines that are being issued that are clearly out of line with reality, our belief systems, it really calls all that into question. And so I look forward to a day when we can be proud of our medical associations as the great organizations that they have been in the past. And I hope that we can see that in the future.
Amen. I might just add my own quick thought is one of the eternal truths expressed in Scripture is that people flourish when they're loved well. And we live in a world that doesn't really know what love means anymore. But for those of us in this room, for people of faith, you steward the clarity on that question of what does it really mean to love someone. It's not loving to encourage someone struggling with gender dysphoria to continue down that path of mutilation. That is cynicism. I think what we'll see in a world where we've won this is people who are actually loved well in their vulnerabilities and their struggles so that they eventually flourish by being loved by the people around them in every aspect of their community. So with that said, we have probably time for 2 questions maximum, I think. So I'd really love to take some, though. So who has a question? Elizabeth, I see you there. I'd love to hear your question or thoughts. Thank you, Robert.
I'm Elizabeth Wanning with Changed Movement, and we focus only on LGBT policy. I hear a lot about the medical institutions. So what has happened for many detransitioners is they've gone in pursuit of emotional care out of psychological distress with a counselor and been told that gender distress or gender incongruence is not a mental illness. And so then being pushed into the medical industry for care. I never hear anyone talking about the reforms that are needed in the psychological world, in that profession. Can you speak to what you would recommend in terms of beginning to turn the tide on where the APAs are going, the American Psychological and American Psychiatric Associations, on this topic?
I think we might defer to you first on that, Kurt, if you're willing.
Sure, absolutely. It's a great question, and it's an important question, because the essence of therapy, and certainly as a psychiatrist, I mean, the essence of the relationship that one has with the patient, with the family, with all those who are before them is just so essential. And it's essential for it to be really authentic and truthful, and not to be pushing an ideology by any means. And unfortunately, there's been tremendous change in institutions where they have been captured by an ideology. And I think it's important for us to recognize that it's a critical time to start speaking out. I was just at the American Psychiatric Association meeting a couple of months ago in Los Angeles, and I was encouraged by the fact that for the first time there was the start of some degree of debate in the American Psychiatric Association by actually having presenters speak to the European data. Granted, the APA also asked for a counter-opinion to be given in a seminar as well, but that was at least the first time that there was an entrance to allowing folks to hear a different point of view. And it is so critical that we continue to press on this. I mean, these are tiny little steps, and we need to do so much more, but I think our continued voices, our voices within the medical establishment, I mean, I'm excited. I'm going to be going to the Pennsylvania Medical Society's House of Delegates. I've worked with some folks to write a resolution so that we can, at least as a medical society, debate the question of stopping pediatric medical transition. And this is what needs to happen throughout medical societies, throughout psychology societies. We need to have this debate. We need to move it forward. We can't be silent. We can't allow ourselves to really have this illusion of trust that the gender clinic knows it all, because unfortunately and clearly they don't. And much of this has been a harm that's come from those clinics. So I think it's important for physicians, for medical providers to wake up to the reality and to start acting like the providers that we were trained to be.
Go ahead, Laura.
Just to follow up on that, downstream of that, if the bill, a part of our provision in the Defining Abuse Act is to cut off training that teaches that it's abuse and that you have to affirm. But you have to replace it with something because of how deeply embedded this is. And so if you have some interest in working on some of that, we're pulling together a coalition to develop that. But I think that judges need to be retrained to understand that gender identity is actually a dissociative disorder, one of many, and they need to be thinking about dissociative, sort of about these disorders and how they come from trauma, they're highly correlated, all these things, that the big picture needs to be understood by judges, social workers, everyone else, so that it's pulled out from this focus on gender, which has no evidence base. And so that's downstream of what you're talking about, but it's a critical piece of affecting change for everyone involved in child welfare and child protection.
Thank you.
There's one thing.
Yeah, go for it, Josh. Go.
For air cover, I'm thinking of the attorneys and the FBCs out there. I certainly think the conversion therapy bans, because even if you're able to change the institution, I was talking to a state rep from Michigan, they're banned from giving that opinion in the state of Michigan. So continuing, I think, to fight those bans. I think Virginia just obtained a consent judgment.
Yes, they did. The Virginia Founding Freedom's Law Center just succeeded in this after a 5-year effort. So talk to them about if you want the playbook.
Absolutely, but just needing to clear that so that as the institutional change happens, there's freedom there.
That is excellent. I'm sorry we're out of time for any more questions, but here's my charge, and then we'll thank our panelists. For the state legislators out here, state FPCs, stand on Skrmetti. It is a springboard for you to press our attack. We have the advantage, we have the momentum, and now we have the mandate. I challenge you. We are here as a coalition of national allies to support and empower you to do that. We just pray you would do it. So thank you for being a part of this. Please join me in thanking our panelists.